Hi, y'all, and welcome to tonight's live stream. Well, I wasn't expecting to have this much to cover if the jury wasn't back yet. There was a really busy day at court. Normally, when the jury's out, it's a little bit quiet, but today there was a ton that happened, and we're going to cover it all. The first thing we're going to talk about is the jury verdict form dispute, which was really heated for a while and which did finally get resolved. We're going to talk about what it was, what happened, how they fixed it. And we are also going to see the clip where the judge called out Karen Reed specifically. We are then going to jointly try to read the tea leaves. The jury sent out 2 questions, which are clues to what they're thinking. And we're going to be talking about what those tell us. We're going to be looking at the charges. I have a chart for you to sort of show what the charges are and what the elements of them are. I'm going to be showing you how you voted on the poll I put out on YouTube, where I asked, what do you think the jury is going to do? And then finally, if we have some time after all that, we're going to take some questions too, some of your questions. So I want to give a shout out to the first 5 who were not already the first 5 yesterday, which would be Michael Lalonde, Abby PJ, Loves My Angel Sue, KS, and Sweetie. So special welcome to y'all and to everybody watching. If you would hit that like button, it'll really help the video get out to more people. And please subscribe. We would love to have you come back. So let's talk about what the jury is thinking. Let's talk about what happened specifically with that argument over the jury verdict form. And this, we're going to start out with what happened first thing or early on, maybe not first thing out of the box, but what happened early on. Here is the judge got called in and she said, why are we here? Why are we all here? And the defense had a problem with the verdict form and they wanted to talk to the judge about it. Let's add that to.
All right, so why are we out here?
Your Honor, I just saw the verdict forms, and as we discussed yesterday, the amendments that the court indicated it would make on the verdict
Oh, no.
forms have not been made.
Okay, I did not say I'd make it. I said I'd think about it. I said I was tired and I needed to think about it.
What you said before you were tired and you needed to think about it was you agreed that there needs to be not guilty options for the subordinate charges under count 2.
I said that it made sense to me, but no, I did not change it upon looking at it because the verdict slip, this verdict slip as submitted to the jury is exactly how it always is in Massachusetts.
So a couple of things about that. First of all, it really surprises me that a verdict slip was, or verdict form, depending on what state you're from, was submitted to the jury without everybody having thoroughly gone over it. It's one of the most important pieces of information that goes to the jury, probably the most important, because it's how they're going to decide the case. When they look at that verdict form, that's how they're going to decide whether or not Karen Reed is guilty or not guilty. And so apparently it didn't get fully vetted in advance and got sent on back. So Jackson is hot under the collar about this, and he lets the judge have it.
Ask your question then. I don't really care how it always is in Massachusetts. I care about whether or not it's appropriate.
It's appropriate.
Two different things.
It's appropriate.
Let me make my argument, if you wouldn't mind, Judge, why it's not appropriate. For a superior charge, they have to decide that she is not guilty of the superior charge, and that is the starting point of whether or not she is guilty or not guilty of any subordinate charge, often called a lesser included. Once they decide that she's not guilty of the superior charge, now there's two additional charges that they've been instructed they must decide whether she's guilty or not guilty of. How do they decide that she's not guilty of the first subordinate charge, involuntary manslaughter?
Okay. Anything else you want to say, Mr. Jackson?
I'd like an answer from the court.
Just
How do
messing
they
up.
decide that she's not guilty of involuntary manslaughter on that verdict form?
That's their decision to make.
And how do they make it if they don't have an option to check a box that says not guilty?
They don't check the box that says guilty, do they? And then when they go to the next block, they don't check the block that says guilty, and on the top, you're left with not guilty. Okay?
So it's the absence of the check mark that the court determines is the not guilty finding by the jury.
Yes, that's what the verdict slip reads. It reads not guilty. If they don't check block 2, 3, or 4, the verdict slip reads not guilty. Okay? That's how it is, Mr. Jackson.
Well, and apparently that's how it's going to be because of the court's order. That is not how it should be, and it's over our strong objection. They need to see that there is a not guilty option for the subordinate charges. If they come back guilty on, for instance, involuntary manslaughter, that's immediately appealable. They didn't have an option on the verdict form to find her not guilty. It's almost like the court is directing a verdict of the subordinate charges.
And we're going to look at the form and we're going to talk about whether that's true or not. But I wanted you to first see what their argument was, what the defense was saying, and how upset everybody is over it, and how Jackson is upset, probably talking to the judge in a way he should not have, in a way that some judges would freak out over. But this judge does not. She stays cool-headed. But she is about to slam Karen Reed. And here you go.
Okay. I disagree with you. Ms. Giannetti, you've seen verdict slips exactly like this, okay?
I actually haven't really.
Have you had no lesser includeds?
No, we've always had lesser included, but I have not seen a verdict slip there where not guilty is not an option for the lesser included.
Okay, I disagree with you. All
I
right,
don't see the
excuse me? This is funny, Ms. Reed? All right, we're done.
Okay. So we, taking a look at what's happened so far, you heard Jackson say he doesn't care what Massachusetts law is. He doesn't care what's normally done. He just wants to do what's right. But in fact, he really does care what Massachusetts normally does. And here's the reason why. Because any deviation from the standard forms is a huge risk for everybody, that there will be an appeal and a reversal on that ground. Judges really like to play it safe. If there's a form, if there's something that's been approved and they know they won't be reversed on it, that's what they want to use. And so there's very little risk of reversal if a judge does what's standard, what's normally accepted in the jurisdiction. It's a much bigger risk if the judge goes out on a limb and does something different. And you can imagine, too, why the appellate court would not want to reverse. Because if this really is standard, if this is exactly what everybody does in Massachusetts for all cases, well, think of the precedent they could be setting if they go out and they change if this judge changes it and the appellate court says, yes, I approve that, or if this court doesn't change it and the appellate court says, yeah, that's been being done wrong all these years. That could mean the reversal of a lot of cases, or at least a potential argument that they ought to be retried. So nobody likes messing around with the verdict forms that have been established, that are set out. Everybody wants to keep those just the way they are. So it's actually a pretty big deal to change them or to do something different. So Judge Cannoni's in a tough spot here. She's got to figure out, making a logical choice, what should she do here? And the defense does have a pretty good point. We're going to look at the verdict form together. Let's go ahead and let me tell you what. I am going to have to, let me add that to the stage because I want to show that to you, what the verdict form looks like. So give me just a second. I'm going to stop sharing that screen and start sharing another screen. Let's see. Is that it? No. Here. There we go. Okay. So ignore that, and we're going to go back. Here is the original verdict form that the jury had. It's kind of a mess, frankly. It's really complicated. I think it would be hard to understand. Here's, you can see, number one, option, not guilty. Number two, guilty of offenses charged, which is manslaughter while operating a motor vehicle under the influence. And you check one or both of the following. Manslaughter, and don't worry, we're going to break this down and talk about what it means. I just want to go through it because it can be a little bit hard to read. And so I want to make sure you can, you hear what it is. So manslaughter while operating a motor vehicle under the influence of alcohol, and or manslaughter while operating a motor vehicle with a blood alcohol level of 0.08% or greater. Number three, guilty of lesser included offense, involuntary manslaughter. Number four, guilty of lesser included charge of motor vehicle homicide, felony OUI liquor and negligence, check one or both of the following, and they have those same two choices about it. Could be operating under the influence of alcohol or operating with a blood alcohol level of 0.08% or greater. So here's what the court wanted. Here's what Massachusetts wants when it does that. The options are for the jury is supposed to check one of these four boxes, any one, but not more than one. So if it's not guilty, fine, all of the rest are irrelevant. If it's guilty of the main offense charged, fine, the other two are irrelevant. If it's guilty of the lesser included offense of involuntary manslaughter, fine, all the other three are irrelevant. So what's supposed to happen is the jury is supposed to look at the main offense, number 2, and say, do we think Karen Reed is guilty of that? If they don't think it's quite sufficient to rise to that level, then they're supposed to consider the next lesser included offense, which is number 3, involuntary manslaughter. And if they look at number 3 and they still don't really think that fits what happened here, then they're supposed to go to number 4 and see if they believe there was motor vehicle homicide. And if they don't believe any of the 3 of those, they're supposed to go back to number 1 and check not guilty. And the reason why not guilty is put first is really for defendants, because defendants don't want not guilty to be the last option. They want to make it real clear to the jury that's an option. Not guilty is an option. You can actually be found not guilty. And so that's why they do it in that order. The problem is that nowhere on this form does it tell the jury, pick just one. Even just saying something really simple like choose one and only one at the top would make it really clear that this is not something where they're supposed to pick a not guilty of the main offense, but guilty of the lesser included is required. The reason that what the defense wanted to make sure happened was that the jury understood not guilty could apply to any of those 3, not just the first one. Now, the judge is going to say she thinks that this is fine. And if this is their normal form in Massachusetts, she's almost certainly right. It's probably something the jury would ultimately reason through and figure its way out. But she did come up with a better solution. Now let's go back to that and I tell you what, I do want to show you one other thing while we're looking at it. No, we're gonna go straight into the video. Let's go back to the video.
I do appreciate the concern about the confusion this might cause the jury.
And to be clear, what's happened is they took a break. Everybody's pretty upset. The judge has dressed down Karen Reed. There were pretty harsh words from Jackson to the judge, and everybody takes a break, little breather. And the judge comes back and says, okay, I've thought about what you said in a calmer mode, and I think we ought to do something. I think we ought to do something about what you said.
It's easily clarified with the supplemental instruction. I don't think it's the verdict slip. I think it's how they're to follow the verdict slip. So what I've written up, this is a very rough draft. I'll read it to you.
I deeply appreciate the court's additional clarifying language. I would simply ask for one very simple amendment, and that is at the top of the verdict slip that says the 2 words, not guilty. We would ask that the verdict slip read, not guilty of the offense charged or any lesser included offense.
So what the judge is, let me stop it right there for a minute. What the judge has suggested, and I cut part of it out because we're about to hear what she actually says to the jury. She says, I want to read this to the jury and tell the jury, explain this whole section a little bit more, which is a really good idea because it really isn't all that clear from that form exactly what the jury is supposed to do and be thinking about. So she says, what I'd like to do is read this instruction, which she's written out in the back to the jury. And Karen Reed's lawyer, Jackson, says, okay, that's good, but I'd really like you to add this phrase. And the judge is going to agree to that.
That and the court's clarifying instruction would satisfy the defense.
Does the Commonwealth oppose the suggestion made by Mr. Jackson, which seems like a reasonable one?
No.
I think the
There's a
clarifying language that I proposed is important.
I do too, and I appreciate that. I think with that amendment to the slip and the clarifying language, I think coupling those up is exactly what the defense was asking for. I appreciate that.
So I do, though, have to make a finding that the verdict slip as is was proper. I want to clarify my...
Okay, so she's saying there was nothing wrong with what I did. It met the normal Massachusetts requirements. And why does she bother to say that? Well, it clears it up for appeal that she is not ruling that what was initially given out was incorrect. She's just going to clarify it at the request of the defense side. So this time they get approval from everybody before the verdict form actually goes back, which is a very good plan and means that there won't be an issue on appeal with this particular issue. So now I want to get to the jury clues, because there were some definite jury clues that came out today that told us a little hint of what they're thinking. And let me sort of explain to you how it works for the attorneys in the room during a trial. There is utter exhaustion by the end of the trial. Everybody has worked themselves for weeks in this particular case, depending on how long your case is. You poured everything into it. You've worked for possibly years, at least multiple hours, many, many hours on this case. And now it's all out of your hands. You are waiting for 12 complete strangers to tell you what they think about all the things that you said and what you did. So it is so stressful, intense. I always used to try to work. I bring work. I never managed. But what everybody does is, since everybody's waiting on these 12 strangers and no one knows what they're going to do, if the jury does anything at all, it is endlessly studied by the attorneys. And so everybody, what did you hear about that? This was, what do you think that meant? Do you think that they were saying this? Do you think they're leaning this way? Why did they ask that question? Everybody talks about it. It'll go, a single question can last the attorneys for a good couple of hours, with people speculating and guessing and coming up with theories. And so that's what we're going to do here. We're just going to speculate and guess what they possibly could mean. The first one you might not see as a clue, but I did. And I want you to hear what happened early in the morning. This is the first hour that they get there, and that's important.
Instructions regarding your verdict is to count 2 of the indictment.
Oh, darn.
As I instructed you yesterday,
Back
there
on
are
the
2
other part.
lesser offenses of that crime, which are involuntary manslaughter and motor vehicle homicide, felony OUI, liquor, and negligence.
So this is what her instruction was. And I'm sorry, I don't want you to miss this. So hold off on that clue. Hold on to that idea for a minute. And let's go back to the other point. This is what she instructed the jury. Remember, I said she wrote out instructions that would be a brand new way for them to think of that verdict form. And it makes a lot more sense.
Therefore, count 2 encompasses 3 separate charges, the most serious of which is manslaughter while operating a motor vehicle under the influence of liquor. In considering count 2, you should first focus on the crime of manslaughter while operating a motor vehicle under the influence of liquor, and if the Commonwealth has failed to prove that crime beyond a reasonable doubt, then you are to consider the remaining lesser included offenses in descending order. So the lead charge is manslaughter while operating a motor vehicle under the influence of liquor. If you find that the Commonwealth has proven all 5 elements of this charge beyond a reasonable doubt, then your verdict shall be guilty of manslaughter while operating a motor vehicle under the influence of liquor. If, however, you find that the Commonwealth has not proven all 5 elements of manslaughter while operating a motor vehicle under the influence of liquor, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the 3 elements of the lesser included offense of involuntary manslaughter. If the Commonwealth has proven the 3 elements of involuntary manslaughter, then your verdict shall be guilty on the lesser included offense of involuntary manslaughter. If, however, you find the Commonwealth has failed to prove beyond a reasonable doubt the crime of manslaughter while operating a motor vehicle under the influence of liquor and the lesser included offense of involuntary manslaughter, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the 5 elements of motor vehicle homicide, felony, OUI, liquor, and negligence. If the Commonwealth has proven beyond a reasonable doubt the 5 elements of motor vehicle homicide, then your verdict shall be guilty of the lesser included offense of motor vehicle homicide, OUI, liquor, and negligence. If, however, the Commonwealth has failed to prove beyond a reasonable doubt all the elements of manslaughter while operating a motor vehicle under the influence of liquor, and has failed to prove all the elements of the lesser included offenses of involuntary
through.
manslaughter or motor vehicle homicide, felony, OUI, liquor, and negligence, then your verdict must be not guilty to count 2. So I'm going to send in a new verdict slip on count 2 that's just a little bit different.
Judge, we're back on the record.
So, okay, all she's saying is it ought to look like one of those decision trees. Manslaughter while operating a motor vehicle while under the influence of liquor. Yes or no? If it's yes, guilty. If it's no, go to the next one. Lesser included involuntary manslaughter. Yes, guilty. No, go down to the next one. Lesser included motor vehicle homicide. Yes, guilty. No, not guilty. That's what it ought to look like to make it more understandable and a little easier for the jury to understand. So she's saying that verbally, and probably people will get that and will understand it, but it is complicated. It is something that is difficult for the jury to really understand, I think, because it's so wordy. But she's trying to walk them through that. And frankly, the form, I think, didn't do a great job of that. So I think it's really good that she did do that. All right, so we're getting back to the jury clues. I know you're wondering, what was the clue? So here's the first clue, and this was first thing out of the box, as I said. It was in the first hour of the morning.
22117. Counsel have both had an opportunity to look at the new verdict slip.
All right, so does the defense say the verdict slip's in order?
Sorry, it's still on the other one.
Okay, does the Commonwealth say the verdict slip's in order?
Yes, Your Honor.
All right, so the verdict slip will go in. Officer Delano, I'll let you do what you're doing.
We're back on the record on 22117. I believe we have a question from the jury.
Yes, it's simply, good morning. The jury is kindly requesting to conclude deliberations in time to board the bus at 4 p.m. A juror has a long existing scheduling conflict. So I'm just going to simply say yes and send it back.
Yes.
No objection.
That's okay.
All right, so all they've done is say that a juror has a long existing scheduling conflict and they want to leave today at 4. They want to be able to not just leave at 4, they want to board the bus at 4 so she can get to the conflict, whatever it was she had to do. So I want us to, we can speculate together on what exactly that means. The fact that it came early in the day means that they were already contemplating the idea that they might go all day, that this might not end. So I want you to vote. I'm going to give you 4 options, 1, 2, 3, and 4. And I want you to vote which one you're, just put it in the chat. Just put your comment in. Okay, number 1, what this could mean is that they knew at 9 a.m. that they had a lot of conflict. There was going to be a lot of disagreement, and they were already settling in for the long battle with pitch sides and people knowing it's going to take a while. We do not agree. That would be number 1. Number 2, listen to all of them first. Number 2, that it's just a really bonded jury. One juror had a problem. They all readily agreed to leave early to accommodate her. This shows they're working together. It means they're pretty likely to reach a verdict together. Number 3, it's not really that they disagreed. They just want to spend a thorough amount of time looking at the evidence. And they know that's going to take a while. So they know it's probably going to take all day. They just really want to make sure they have the focus that the case deserves as they believe it. And then number 4, it really didn't mean anything. It was just a housekeeping matter. It could go till 4. Nobody had any idea, so they just threw it out. Spoiler alert, it did go till 4, and the jury did go home for the day. Actually, a little bit more like 3:30 they left. So number 1 is going to be they disagree. It's going to be a fight. Number 2, they're really bonded and working together. Number 3, they just want to spend focused time on the evidence. They just want to take their time. And number 4, it's just a housekeeping matter. So 1, disagreement. 2, they're bonded. 3, they want to spend time with the evidence. And 4, it's just housekeeping. So I'm curious what everybody thinks. Block in your votes, as they say. And we won't be able to tabulate them. I don't have a poll function here in the streaming service that I use. So I don't have the ability to do that. I'm sorry about that. But we will get your poll that you answered earlier today in YouTube. So don't worry, I'll be showing you that in just a minute. So I will, let's see, I'm curious. Oh, people are all over the map. 1, 3, 4. I'm not seeing any 2s. I'm with you. I don't think it's 2 either. Well, there's a 2. Patty's Home believes it's a 2. Patricia believes it's a 2. Amy, lots of votes. This is impressive. Okay. So here's sort of my take on it. I think it was a combination of number 4 and 1. That's not fair, right? I made y'all pick. But I think it means that they were in disagreement. I think it means that they thought they would need all day plus some because they weren't fully in agreement. And therefore, they wanted to just go ahead and take that out of the way. Now, there are overtones of the others. They asked this for one particular juror. That means everybody was bending to what she wanted. And it does mean they're focused on the evidence because they're having to convince each other about what they think the result is. So I think it's a little bit of a blend, but I would probably go with number 1, that they were having some significant disagreements and thought, let's just plan ahead that it's going to be more than just today. So that's my vote, but who knows, right? And I'm telling you, this is what lawyers do. They sit around and speculate and guess, and everybody will throw in their 2 cents about what it might mean. So you are doing exactly what the lawyers almost surely did today. So here, jury clue number 2. This is what we're going to be looking. It's a question that the jury asked for, and the judge talked to the lawyers, said, this is what I'm going to do. And here's what she gave back to the jury. They asked for a specific document, the search report. And we'll talk about it in just a minute.
All right. So jurors, we're in receipt of your question. Can we request the cert report detailing the search performed? I take this as a request, and the answer is that you folks, you have all the evidence in the case. So what you have is the evidence in the case. You won't be receiving any additional evidence.
Okay, so what does that mean exactly? What she says, and she talked about it with the lawyers first. She said, I've got this question. They want this cert report. They don't get the cert report. And so I can't give it to them. It's not in evidence. The only thing the jury can take back with them is things that are in evidence. But this means they were so focused on the case that they really wanted that cert report. That was important to them. We're going to talk about a couple of different reasons why it might be important. We're going to use our timeline and then look at something that was argued at closing, and we're going to look at how it sort of played out at trial. So we're going to look at those 2 things. So I want to do a threshold question, though. Why don't they get the cert report? Like, why not? Why not give them that cert report? And the answer is, the judge didn't say it, but I assume it's because it's considered hearsay. Now, that's not always the case. I looked up the difference between Massachusetts law and the federal law, and there are differences in the way the hearsay rule would treat a report like this. In many jurisdictions, I think they would get the cert report, but under Massachusetts law, they can't get the reports. Those aren't actual evidence because they include opinions and things that are said that report what other people said and other people did. And so that's how it works out. But let's talk about why. Why would the jury want this cert report? Why is it so important? So the first possible issue is that let me go ahead and pull that out and talk to you a little bit more directly because I'm going to be showing you a different document. So the first possibility is that cert team came in. Remember, John O'Keefe was killed in the morning at 5:30 p.m. Just about. That cert team came in and began looking for evidence. They said they pulled their cars up. They shone lights on it so they could try to see where John O'Keefe had been. They were told this is about where the body was, and they began to look for evidence. and they found some pieces of broken taillight. Hugely controversial because the defense says those pieces of taillight, they're only there because Trooper Proctor broke her taillight and planted evidence at the scene. So one possibility is that the jury wants to check the time and the date on that report. Let me go ahead and I'm going to add to the screen. I am going to share a screen with you that is our timeline. And this timeline, we are corporately very proud of this timeline because it was done not just by me, but it was also done by a group of people, and it was by the members. We all had a special meeting where we went over what some of the evidence was. We tried to come up with what are the things that people would really want to know about this case to try to do the timeline. And then some of our members even took extra assignments and went back and reviewed the testimony from a day to make sure we had everything. And we still have some things, there's still some things people have sent me that I need to add. But the great thing about this timeline is we can now take a look at it, and I'm going to make it a little bit bigger for y'all. Maybe take it up to, let's see if we can fit that on the screen. Yeah, I think I can fit that. What I want to do is take a look at what are some things we can tell about the CERT report from our timeline. And I've turned those into yellow just so they'd be easy to spot. And there's quite a bit about this. So let's take a look here. Oh, sorry, that's the snowplow driver. I also put that in yellow, thus confusing me. Okay, so at 2:30 p.m., Lieutenant Tully phoned Lieutenant O'Hara to inform him about John O'Keefe and about the incident and to dispatch the CERT, Special Emergency Response Team, to the scene. We know that they weren't there at 2:30. They didn't even know about it until 2:30, and it takes them a little bit of time to gather and to get there to the scene. So at 4:16 p.m., Karen Reed's car is towed from 1 Dighton, her father's home, and Buchanan and Proctor are there. So at 4:16 p.m., we now know that Trooper Proctor has possession of Karen Reed's car. So there is overlap because it's then at 5:30 that the search begins in the 34 Fairview yard where O'Keefe was found. And they used a blower, plastic solo cups. They collected some evidence, including pieces from the taillight. So there is overlap. That car, the taillight, was in the possession of the troopers of the state police before the pieces of taillight were found. That's important to the theory the defense has, that they were planted. Then at 5:37, we see Karen Reed's car pulling into the Canton Police Department Sally Port. The last member of the CERT team arrives at the house at 5:41. And then we have some calls between Brian Albert, the homeowner, and Brian Higgins shortly after that at 6:12 and at 6:35. I left that in because it could relate depending on what they were talking about. Higgins had been at the police station all day. And now, of course, Karen Reed's car is at the police station. Okay, so to everyone's surprise, that discovery was, and I have two different conflicting things here. We'll have to work that out. But that was not the first time that taillight pieces were found, or wasn't the only time. It was the first time. It wasn't the only time that pieces of taillight were found at the scene. It kept going. There were more pieces found on February 4th, and more found on February 8th, and more found on February 10th. I can't remember if Berkowitz is the 4th or the 10th. You can see I have it here twice, so one of those is incorrect. That particular one, the defense says that's some kind of crazy because the chief was driving by and spotted a piece of taillight in the yard that everyone else had missed while driving by on the street. They say these were just additional plantings of information, that all of these taillight pieces just kept getting planted so that they would be found. I don't know why they didn't plant them all at once, but they're saying it happened over time, and that the taillight pieces were there only because they were planted. The prosecution says the reason we kept finding taillight pieces is because there'd been a blizzard and now the snow was melting. And so things were being exposed. And that's why we found new pieces. But that's why this is so critically important. So let's go ahead and pull that out. And that is one possibility of why it really matters that they asked for the CERT report, which they didn't get, but they may have been looking for some of that timing. They may have been looking for that. But there's another possibility why that's so important. That CERT report wasn't written bizarrely until a year after the search, which I find really mystifying. That's very strange. But on the stand, Karen Reed's attorney, Alan Jackson, proved that the report says that they found 3 pieces of taillight, but the bags of evidence that were presented to the jury at trial had 5 pieces in them. So it didn't match what the report said. It was magically appearing plastic. So let's take a listen to how this happened at trial.
As long as I have you here.
According to your report, on February 10th, a piece of red plastic was found first. Then a piece of clear plastic was found. Then a piece of red plastic was found thereafter, correct? According to that report.
Yes.
Then you go on in the following paragraph to reiterate, just to clear up any doubt about what was found. And the last sentence reads, the sneaker and 3 pieces of plastic were secured as evidence, correct?
Yes.
Yesterday, you pulled out 2 pieces and indicated that was what was contained in the bag, correct?
Correct.
Take another closer look.
As I take a closer look, there are 2 pieces and there is a very small fragment that remains in the bag.
Can you pull that fragment out as well? Can you show that to the jury? Okay, you can go ahead and replace that. So in total, Lieutenant Tully, how many pieces of red plastic are in that evidence bag?
As we sit here today, there are 3.
Thank you. Go ahead and close that. The next bag is Exhibit 571, is that right?
Yes.
Could you please open that and let's go through the same process?
Inside 571, there are 2 pieces of clear plastic.
There are 5 items in that bag, or in those 2 bags, right? Just the plastic.
Correct.
And yet your report very clearly says there were 3 items of plastic evidence recovered at the scene, correct?
Yes.
So my question, once again, is where did the extra 2 items come from, the pieces of plastic?
Well, as memorialized on the bag, it says pieces of clear plastic. So I'll take the hit that my report does not properly memorialize it. But I would argue that the handwritten notes on the bag that are contemporaneous to the collection of the evidence would be more accurate, as is my memory of 2 clear plastic things being collected. Now, as to the 3rd piece, again, I'm making an assumption, but it appears that that is a small piece that was separated from the other 2 pieces.
You don't know that that small piece separated from the other 2 by being broken off, do you?
No, I don't.
The law.
Okay, so let's go ahead and pull that out. And I will talk to y'all a little more directly. So either way, well, if this had to do with the pieces that mysteriously appeared, or whether it had to do with the timing of when the vehicle was towed and when the first pieces of taillight appeared, either way, it seems like the jury was specifically looking at some issues that had to do with whether or not law enforcement was committing misdeeds, whether or not there was some kind of wrongdoing on the part of law enforcement, and could they have been framing Karen Reed. It seems like they were looking at Karen Reed's conspiracy theory, and they were considering whether or not the troopers had planted evidence. I think both of those kind of head in that direction. You know, that could be a good sign for Karen Reed because it means they are at least considering her arguments. It's also a sign, though, that they aren't all in agreement. The fact that they need that report to try to persuade other people of something in the report suggests that they don't yet agree, that they have some questions among themselves about what it is. So I see that we have a bunch of questions. I'm going to go ahead and I do want to get, it's already 7:44. Okay. I do want to get into the charges. I have a chart for you, and I just think it'll kind of help make it understandable, sort of. They're always a little confusing, but trust me, it's better than listening to a 30-minute long explanation of what it is. So I'm going to take a look at that. I also want to answer some of the questions that are popping up over here. And so thank you everybody for the super chats. It means a great deal to letting me keep going with doing this. I thank you for doing that. And I'm going to go back and try to answer the questions. I'll try to pop these up on the screen, but then go back and answer the questions. So I'm going to have to share yet another screen with you. There's a lot going on here. So let's find the one I want to share with you. There it is. Okay. So here is the chart I did, and I'm going to blow it up a little bit so you can, that was the opposite, right? You're thinking that did not help. That did not make it bigger. So let's take it on that. Well, yeah, 200%. That'll really help. Okay. So I'll roll it back and forth so you can see that there are 3 primary levels of charges. Number 1, second-degree murder, assault with intent to murder. Number 2, manslaughter while operating a motor vehicle while under the influence of liquor. And there are 2 lesser included charges under that: involuntary manslaughter and motor vehicle homicide. The third is leaving the scene of a collision resulting in death. So I put them all in different colors so you can kind of see across it. So the first column tells you what the charge is. And the second is, what are the elements? And by elements, what we mean is the things that have to be proven for Karen Read to be found guilty. So let's take second-degree murder. The 2 things that the Commonwealth has to prove for Karen Read to be found guilty are that she caused the death of John O'Keefe and that she intended to do one of the following 3 things. Number 1, she intended to kill John O'Keefe, or that she intended to cause grievous bodily harm to John O'Keefe, or that she intended to do an act that in circumstances known to defendant, a reasonable person would have known created a plain and strong likelihood that death would result. So if you take the sort of least of that, which would be number C, it still means they have to prove that she caused the death of John O'Keefe and she intended to do an act that would create a likelihood of that happening, that she intended to do something that would make that not just possible, but strong likelihood that death would result. Not just that he would be hurt, but that death would result. It's a strong charge, and it has that intent level. She has to have actually intended, purposefully wanted those things to happen. And so that is the biggest charge that Karen Read has. The others are less serious charges, but still obviously very serious. The second one is manslaughter while operating a motor vehicle while under the influence of liquor. And there are 5 elements of that. The first is operated a motor vehicle upon a public way. And notice that the first one didn't mention operated a motor vehicle, but she has to have caused the death. The only way the prosecution says she could have caused the death is by hitting John O'Keefe with her car. So for second-degree murder, a necessary element is that she has to have been driving the car and she has to have hit John O'Keefe intentionally. Then the second one, the manslaughter, she has to have been operating a motor vehicle. Again, she has to have done this with her car. This is not being beaten up. This is with the car upon a public way. That just means not in your backyard or on private property. This is on a road. While operating, was under the influence of intoxicating liquor or had a blood alcohol of 0.08 or higher. We saw that on that verdict form. Number 4, operated the vehicle wantonly or recklessly, so likelihood that substantial harm will result to another. And I wanted to throw in a couple of notes here. It's not enough that she was negligent. She has to have been wanton or reckless. She has to have operated in a way that there was a likelihood that substantial harm would result to another. But she doesn't have to have an intent to kill John O'Keefe. She just has to have been so reckless that it's likely that somebody could get hurt, and he's the one who did. And number 5, by such operation, the motor vehicle caused the death of John O'Keefe. So once again, there has to be an actual causing of the death of John O'Keefe. Now, those 2 lesser charges, let me take just a quick break because I'm running behind on thanking everybody, and I do really appreciate it. I can't, where was I on the list over here? Well, I don't want to take too long a break. Oh, there we go. Okay, I'll show a couple of these. And so thank you so much to everybody. I really do appreciate it. So let's take a look at these lesser included offenses. The first, involuntary manslaughter. The second, motor vehicle homicide, felony OUI, operating under the influence, liquor, and negligence. Liquor as opposed to drugs, say, and negligence. So let's take involuntary manslaughter. 3 things that have to be proven. Number 1, the defendant caused John O'Keefe's death. She did it. She was the one who caused the death. Number 2, she intended the conduct that caused the death, and you can consider the alcohol. Now, that's different from intended the death. She intended the conduct. She intended to drive drunk. She intended to drive, and she knew she was drunk, for example, and that caused the death. That would be what that means. Number 3, the conduct was wanton or reckless and created a grave risk of harm with indifference to or disregard of consequences. So that's the top lesser included. If the jury can't find the first one, manslaughter while operating, and can't find the involuntary manslaughter, then it goes to the third lesser included, motor vehicle homicide. And the 5 elements are: defendant operated a motor vehicle on the public way while operating was under the influence or had that blood alcohol 0.08 or greater, operated the vehicle in a negligent manner, so lives and safety of the public might be endangered, and by operation of the motor vehicle caused the death of John O'Keefe. See how all of these require her to have actually killed him with the car. So if, in fact, the taillight, she never collided with him, the taillight wasn't there, all of these charges don't fit what happened. And the third primary charge is leaving the scene of a collision resulting in death, and the Commonwealth has to prove 6 things. Number 1, that the defendant operated a motor vehicle, again, on a public way. Defendant knowingly collided with John O'Keefe. Now, that's different, by the way. Knowingly collided with him, she doesn't mean she knew she was going to, she intended it. It means she collided with him and she knew about it. She realized it. Because, see, this is leaving the scene. So if she had no clue that she had hit John O'Keefe, then leaving the scene doesn't fit this. She has to have known that she collided with him. Number 4, collision caused injury to John O'Keefe, resulting in his death. Number 5, after causing such injury, the defendant failed to stop and provide the information that you provide after a wreck. And number 6, the reason she did it, failed to do so for purpose of avoiding prosecution or apprehension. So those are the charges that have been levied against Karen Reed, and those are the things that the state will have to prove in order to win on those. So here's what I'm going to do. I'm going to go ahead and show the poll results, or at least tell you about the poll results. I was going to refresh and tell you. Now, I put out a poll today and I said, in the Karen Reed trial, which way do you think the jury is going to go? And 71% of you think that the jury is going to find Karen Reed not guilty on all 3 of those primary counts that I told you about. 15% of you think the jury may find her guilty on some counts and not guilty on other counts. 3% say guilty on every count. 12% say it's going to be a hung jury. So we are split, but the pretty vast majority, 71%, believe she's going to be found not guilty. So FYI, that's what you think. That's what you were voting for. Connie, welcome. I'm glad you have been a member for 4 months. That's fantastic. And it was unusual. Connie is pointing out that the judge picked the foreperson. That's apparently their custom. You may remember that happened in the Murdoch case too. It was the first time I'd ever heard of that. But the judge selected the foreperson. And so apparently that's done in some jurisdictions, not in ones that I've practiced in, but that is done. Thank you, John, for your gift of lawyerly memberships. We'd love to have you as a member. It's a way of financially supporting the channel. You don't ever have to do that. And I'm going to go back and answer. Thank you, Cutley. And I'm going to go back and answer some of these that were questions. And meanwhile, if you could be putting your questions in the chat, I'll go back and answer some of those as much as we have time to do. Now, the way that I will be able to better spot your question is if you put some question marks at the beginning. That makes it a lot easier for me to see it, because it can be pretty hard when the chat is moving to capture one and figure out what the questions are. So Glenda asked me about the swans. I mean, who doesn't like swans? But I don't collect them in particular. I just happen to have some back there. Thank you for noticing. Okay, just my insights asks, what if it's not guilty on the main manslaughter, but they're hung up on one of the lesser charges? So that can definitely happen. They can be hung on any of these charges. They can be hung on all of the charges. But if they can't reach a decision that is across the board, all 12 of them agree on it, then that's what the judge will have to declare. They're going to wait a long time, I would think, before they declare that, because this is such a huge effort by so many people, and no one is going to want a hung jury. Not the jury, not the lawyers, not the judge. Nobody is in favor of that. Not the taxpayers, because this is an expensive proposition. So if there is a hung jury, I will say that I don't think that's a good thing for Karen Reed. On the one hand, it means she wasn't convicted. On the other hand, it means it has to be done again. And I don't think her team is going to do better than they did at this particular trial. I think they did really well. The prosecution will be better prepared next time to deal with exactly what was thrown out. I think it would be a difficult thing for her the second time around. Not difficult, more difficult. I think it would not be as easy. The only exception to that would be depending on what comes back with the federal charges, if anything. We know very little about that. And I saw there was another question in here. R wanted to know, do you think the Commonwealth even tried to prove intent? I think they tried in terms of their proof that Karen Reed, and they played it in closing arguments, her yelling, "I hate you," to John O'Keefe that very night, possibly after she hit him, that they had that argument in Aruba. That was the Commonwealth's attempt to show that this was intentional. They also talked about her accelerating backwards at 24 miles an hour over a 60-foot span, saying that acceleration was intentional. She was trying to hit him. She at least was trying to hurt him or run into him. Whether or not she fully intended the murder or not will be up to the jury to decide. Jessica is asking me about the federal jurisdiction and what will happen there. We know very little about exactly what's happening. As I understand it, the U.S. attorney is investigating, and it relates to Trooper Proctor. It relates to this case. Exactly what's happened, we don't know, but we got a clear view during the trial that everybody we saw was brought in before a federal grand jury. So they have thoroughly looked at it. They have talked to all of these witnesses. They hired the reconstructionist that the defense used as their reconstructionist. They have done a thorough job on this. We don't know yet about any charges that have come out, but we are pretty sure that it involves, well, we know it involves Trooper Proctor, and that it may involve other people as well. Okay, so I'm looking for other questions here in this section, then I'm going to go over to the main chat. Jury question 1, did state medical witnesses say the victim was hit by the car? Answer, no, in the trial. RNC is saying the fact that the medical examiners didn't talk about, in fact, refused to say that she was definitely hit by a car. They said instead that the manner of death was undetermined. I do think that the jury still could decide that there was a vehicle strike here because of some of the pieces of evidence that they had access to that the medical examiner didn't. But that is a huge argument that the defense made, and it is persuasive, even if it isn't ultimately what exactly if it doesn't completely overlap and completely prevent. On Gingy Probs asked about the evidence that she was drunk. There was evidence presented of her blood alcohol being taken the next morning, something after 9 a.m. when she was taken to the hospital. And they brought in experts, medical people who calculated backwards and said, okay, if her blood alcohol was this level when we took it in the morning, tracking back, this is what it would have been at 12:45 or so when she hit John O'Keefe. And there were some assumptions in that the defense undermined, but there was actual testimony that at the time her blood alcohol would have been something between 0.13 and 0.2 something, which would be anywhere in that range would be over the limit that's set by Massachusetts law, over the 0.08. And thank you, Florida girl. I really appreciate the super sticker. Okay, so let's head over and see what additional questions we get. I'll have to backtrack. I should probably wait until the very end before I even ask for that. Okay, let's see where we are. Wow, there are a ton of comments. Okay, which I love. Thank you. Thank you, everybody, for commenting. Lots of votes on the 3s and 4s and lots of different votes on that. All right, going down to the very end. And I'm going to zip back up. I may just have to go from the end. Okay, I'm just going to start grabbing some questions and answering. If you put yours in too early, try to put it down again. Maybe I'll get to it. Selena asked me, will or can the prosecution gather more evidence, or do they have to use what they already have? That is a good question, Selena, but the evidence has closed. So there is no more evidence. Nothing else can be presented to the jury. They have to decide based on what they have right now. If there were to be a new trial, then perhaps new evidence, if it were found, could be presented to the jury. But to this jury, this is all the evidence. There's nothing more that will be shown to them. Gray Cat, don't they take pictures of the evidence? Yeah, in the Troconis case, they had pictures, everything labeled. They also had the ability to request testimony, the transcripts of testimony. And they would, this way, they said, then they would know how many pieces of taillight were collected. So that's true. In the Troconis case, they were given access to some things that it sounds like they don't have access to here. One of the things was the transcript, and the judge told them here there would be no transcripts being sent out. But in the Troconis case, the jury asked for a couple of transcripts. They wanted to look over specifically what had been said by that particular witness at trial. So I would think that they do have the pieces of the taillight. I would think they do have the envelopes and they can look inside them. I would think that would be with them in the back there. And so they can see how many pieces are in there. Allie wants to know, if you're a juror, do you want a box that says not guilty by every charge? That is a good question. I think that would actually make sense. I think it also needs to be really clear that the jury doesn't decide, as we looked at that form, doesn't vote guilty on number 2 and guilty on number 3 and guilty on number 4. Say, well, we found this, so clearly she's also guilty of number 3 and number 4. And I can see a jury thinking that. I can see a jury believing that's how they should fill it out. So I think there also needs to be something on the form that says here, and if not here, then here. And if not there, then here. It needs to be more specific. I do think it would be better. However, if that's how they customarily do it, I don't think it would have been reversible. I think she's correct. And I think the jury could have pieced it together. You just could make it a little clearer. And I think the judge did. And the defense was happy with that and agreed with what it was. And the prosecution agreed with it as well. Loretta asks, have there been any research correlating a defendant's appearance to guilt or innocence? Are beautiful people less likely to be convicted? What an interesting question, Loretta. I don't know the answer to that. I would think the answer is yes, but I don't know. I haven't ever seen a study on that, and I sure would like to. That would be really an interesting study. Good question. Robin wants to know if Karen is found not guilty, can she sue? And we talked about that a little bit last night as well. I think it would be a very difficult proposition because the prosecution did have a significant amount of evidence. Now, it may have been placed there, and if so, that's another issue. If the feds managed to prove, if Proctor goes to jail, maybe some of that, but there was still a fair amount of evidence, and I think it would be a very difficult case to win. As an attorney, I would advise Karen, don't push that. Just accept the fact that you walk away scot-free. What will she do? I don't know. That's what I would suggest to my client in this situation. Laura Lee Annie wants to know, do you think that Commonwealth having defense close first is more difficult for the prosecution or the defense? So, and she is from, Laura Lee Annie is from Massachusetts. I've never seen it before either. It was very unusual. I'm used to normally the prosecution goes first, then the defense, and sometimes the prosecution saves a piece of its time, so it also gets to go last. Actually in our state, we have a weird situation where the defense can sometimes go first, but that's a specialized situation. But as far as what effect it had, I think it's an advantage for the defense because normally the jury hears the Commonwealth pound, or whoever the prosecution is, pound on how the jury should look at all the evidence and see it directly showing how Karen Read was guilty, would hear all that. And only then do they hear the defense, and then they get to hear the prosecution again. I think it's certainly either better to be the only person going last or the only person going first. So I think this is an advantage for defense overall. Lisa asked, did the FBI investment get triggered or regulated by the defense? Did the FBI investment? I'm sorry, I don't understand that question. Maybe explain it a little more, Lisa, and I'll see if I can answer that. Glenda asked, could the governor overturn the verdict? No. Now, the governor could pardon somebody, at least in most states, but it wouldn't literally overturn the verdict. The verdict would still be in place. An appellate court could overturn the case, send it back for another trial or for some other kind of proceeding. Momo Shark wants to know what sentences are available, and they're up to a maximum of life in prison with parole no sooner than 15 years. We'll have to go over that another night. I don't have all my details here, but that's a good question, an interesting question. Sarah wants to know, how can they prove Karen Read was driving under the influence or operating under the influence? I think they call it in Massachusetts. I think they did that with the alcohol testimony. I think that was fairly strong. That you can disagree with it. You can say that there were questions about whether she'd had drinks afterwards, and maybe that threw the numbers off. But I think from just did they offer the evidence standpoint, yeah, I think they at least offered the evidence. I'm going to head back over and do a couple more. I'm looking for the question marks at the beginning. Remember that. There's Jenny wants to know, does involuntary manslaughter include the motor vehicle, or just all of these require the motor vehicle? If she wasn't operating the motor vehicle, or if it wasn't the motor vehicle that killed John O'Keefe, because that's the only evidence that she had any involvement with his death, is the idea by the prosecution that she hit him with her car. So if he didn't get hit by a car, if they didn't prove that he got hit by a car, then she goes free. That's my personal opinion anyway. Okay, so let me add a few more people. Bethany, that's a good one. What's the one story about George that makes you laugh every time you remember, think about it? You know, I'm gonna have to think about that. That's a great question, though. I really like that, Bethany. My husband George died last month, so I appreciate your asking about him. RN, jury can't make up the evidence. True. Jury shouldn't override the medical testimony, not their job. Also true. And thank you, Regina. Okay, let's go back over, get a few more questions. BG, what do you think of Brian Albert, Jim McCabe, and Colin in the courtroom? That's something that is very unusual, particularly because this courtroom is so incredibly small. They're sitting right up almost next to the defendant and the defense team. It's a strange feel. Normally, they would be sitting in the back. It just would seem less of a sort of looming presence, but they're sitting right there in view of the camera. Karen, her team, and the Alberts, and I find it really strange. I find it very unusual. I've never seen that before, but part of it I think has to do with the layout of the courtroom. I don't think there's anything wrong with them being in the courtroom or watching. It just feels tenser, I think, because of that, because everybody is right there in such a tiny area. Gray Bookworm wants to know, would you have accepted the task of prosecuting this case? So if asked to, I think a prosecutor would take the cases that were assigned and prosecute them if they believed it was a meritorious case. So I think the answer is yes. If you work, anybody works for a lawyer works for the prosecutor and gets assigned the case, as long as it's meritorious, I think they would do it. The more of a choice comes with the defense when the person comes to you and says, here's my case. What do you think? Will you take it? And what's interesting here is that the defense lawyers took the case, and I'm sure they were fully compensated, but they took the case before they knew a lot of the information that they presented at trial. They're the ones who got all of this information, gathered it together, who figured out the holes in the Commonwealth's case. And so they went into it without knowing that they had all of that information. Robin wants to know, Lally lied about the position of John's arm at the time. So we've talked about that and exactly what it is that was said by Trooper Paul. So I think there are differences of opinion on what exactly he said. He clearly said John was hit on the arm. The question is, was the arm outstretched and so forth? Lally says he didn't say it was outstretched, but it's up to the jury to remember what Trooper Paul said. And to say, hey, Lally got that wrong. Trooper Paul said the arm was outstretched, but they're fully entitled to do that. They are able to do that. Annie K, good to see you in the chat again. Do you think there are any worthy appellate issues? I think there are some. I think that some of the issues relate to evidence that was in or out. I think the whole looming federal investigation is something that may raise its head on appeal. So yeah, I think there are some. Obviously, one that's not going to be an issue this time around is that jury verdict form, since they did get that all worked out. But I think there are appellate issues for both sides, more for Karen Reed, I think, than for the prosecution. I don't really see that the judge has bent over backwards for the defense. So I don't see a lot for the prosecution, but there are always things in there. We don't have access to some of the rulings she made. So there will be some things. And I will tell you, one of the things the attorneys are doing right now as they go through the trial, they're making lists of everything that they think might be an appellate issue. So I personally I'd like draw a little circle like on my pad. So I would make sure that I could go back. Yes, the judge ruled this. I think this could be a possible appellate issue. And that's one of the things that you're constantly on the lookout for. There are always some. What exactly they'll be here, I don't know, but there's always something. And now I do want to clarify, there's a difference between having an appellate issue and winning the appellate issue. Two entirely different things. Dee's Apples. What happens if she's found guilty and the DOJ indicts Proctor? Is it immediately appealable? No, because those are different things and different jurisdictions. Here's an example. Let's say Proctor is indicted and it has something to do with this case, but it might not be a sufficient level to overturn Karen Reed's conviction. Is it going to be an appeal issue? Absolutely. But is it going to be enough? The appellate court might say, we think the verdict is solid. We don't think that little thing related to this that he's charged with, we don't think that undoes her conviction. We're going to uphold it. So it's still possible that her conviction would be upheld. It would not be something that would immediately spring her from jail or be immediately something that would merit an appeal. I do think they must be waiting for this trial to be over to release some of that information, because I don't really see what other reason there would be for them not to have released that. All right, I'm looking for here we go. Michelle asking me, very interesting watching. She's watching a couple of the places that are broadcasting it and seems a bit biased on the media. I think that's always interesting. Certainly as you watch the chat roll by, I haven't been watching those two. She's been watching Court TV and Law and Crime. But I see that there seems to be sort of a general consensus among the people who are watching that they believe Karen Read has been framed. If you were to ask, it's about what our poll said. About 71% probably think that Karen Read will be found or should be found not guilty. And 30% think that the prosecution's case is stronger. So maybe that's just my sort of off the cuff guess as to percentages, but that's kind of how I see it unfolding. I see that, and it may be that they're sort of reflecting that in what they're reporting or covering. I haven't noticed specifically that there was any kind of bias by the media, but I have noticed a direction that the chat takes and that the people talking about the case. Okay, heading back over here. Thank you, John. I appreciate it. Could you do a stream regarding Judges Peterson and Glanville in Georgia? So I'll have to look into that. I know that Glanville is, of course, doing the case related it's a gigantic case. It's been lasting for a year, and he's recently gotten into a battle with Brian Steele, one of the attorneys for the defense, for a defendant. There are multiple defendants. That is a really interesting case. I have not done that. Part of the reason being that I know a lot of the people involved. So that, to me, I kind of held back. Oh, good. We get a joke from Liz. It's recommended when traveling through Massachusetts that you take an attorney, a social media expert, and a forensic investigator. I guess never a bad idea. Okay. All right. Well, we will wrap it up for the day. Tomorrow night, we will be back at 7 p.m. Eastern. We may have a verdict. 71% of you think that the verdict is going to be not guilty on all counts. Will it be? We will find out. We will talk some more. I still have some things I want to do with our timeline. And the number one thing I want to do is take a look through it and put together a video for you on the third-party culprit argument. Really, the only thing we heard about at trial, there were no charges related to it, was we heard a good deal about Brian Higgins. We heard some about Colin Albert. We're going to break all that down and we're going to take a look at that. If it's not tomorrow, then it'll be the day after that. But I will see you tomorrow night at 7 p.m. Eastern.